When cross-examining a medical expert in a medical malpractice case, why is it important to rule out and to eliminate those things that the doctor did not rely on in order to reach his conclusions? You want to know the answer? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injuries and that your injuries are significant and permanent. The doctor denies all of your allegations and says, I will see you in court. Okay, so now 2 or 3 years down the road, your case finally gets to trial. And now, during the course of trial, after we have finished putting on whatever proof is necessary, the defense goes ahead and puts on their medical experts to show the jury, or at least try and show the jury, that our claims have no merit whatsoever. So now, after the defense attorney has finished questioning their own medical expert, the judge will turn to me and say, Mr. Oginski, you may begin your cross-examination. Now, once I begin my cross-examination, I will want to ask the doctor not just what medical records he reviewed in order to reach his conclusions, but I will also want to try and whittle away and identify what things were not important that this doctor may have relied upon in order to reach his conclusions. You see, there are many times where an expert will say, yes, but the patient could have the following problems, when in fact, the injured patient did not have those problems or did not have all of those problems. So now we want to try and lock the doctor into exactly what it is that this patient did have and what things he didn't have. Because now I want to show the jury, listen, this patient didn't have all of these things, and the doctor, even though he said, yes, I would be relying on all of these things, the fact is, if this patient only had one of those things, now I have to ask him, doctor, would you agree that this patient didn't have number 1, this patient didn't have number 2, this patient didn't have number 3, like you talked about when you were asked this question by your attorney. Isn't that right? Yes. He did have number 4, isn't that correct? Yes. Okay, so it's critically important to be able to show the jury that even though this expert is talking about various things that the patient might have had, the fact is, in this particular instance, the patient didn't have all those other things. So now we have to identify exactly what it is that the patient really did have and try and get the doctor to admit that his opinions are based only on certain particular facts that now we can isolate for the jury and compare it to what our expert has said about those exact facts. Let me give you a perfect example. I was in court the other day and I happened to walk into a courtroom where they were on trial. It was a case involving a failure to diagnose cardiomyopathy resulting in death. All right, so now what happened? So now the doctor's medical expert, the person who's being sued, the defense, put on a medical expert, a cardiologist, and now he's telling the jury the different possible reasons why this patient died. And all of a sudden he says, you know, this patient could have died because of something called stress-induced cardiomyopathy. He tells the jury, you know, there's not a lot of literature to support this particular conclusion, but there's nothing else in this patient's medical records which are going to point me to exactly why this person died. So it's my opinion that this person died because of this stress-induced cardiomyopathy. And you know what I thought as I'm listening to this? What total bull! This is total bull. He's making this stuff up because now he's telling the jury a conclusion about something that he clearly has no information, no factual basis to make this conclusion. So now, on cross-examination, the injured patient's attorney gets up to do his cross-examination. And during the course of cross-examination, what does he do? He does the right thing. He starts by eliminating those things that the doctor did not rely on in order to reach his conclusion. Doctor, would you agree that every single doctor who saw this patient did not conclude that this patient had cardiomyopathy? Yes, that's true. Would you agree that this team of doctors who saw him and treated him for a period of months never, ever concluded that this patient had this particular condition? Yes, I would. And would you agree that the next team of doctors who saw him in the hospital also never came to the conclusion that this patient had this particular condition? Yes, I would. So what is this lawyer doing? This plaintiff's attorney, the injured patient's attorney, is getting this medical expert to go ahead and correctly identify that there is nothing in this patient's history or medical records to indicate that anybody who ever treated him ever came to this conclusion. And now here's this doctor who's doing a medical legal review on behalf of the doctor who's being sued. And what is he doing? He's saying, listen, even though all these doctors who treated him couldn't come to a decision or conclusion about why this patient had this problem, I, simply by reading his medical records in a short period of time, I have the answer. And what's the answer, doctor? The answer is, it's not in any of the records. It's stress-induced cardiomyopathy. This was amazing. And I am positive that during closing arguments, the injured patient's attorney will turn to the jury and say, ladies and gentlemen, what was this argument? What was this discussion by the defense's expert about how this patient developed this condition? It's absolute nonsense and not based upon the facts of this case. So why do I share this great information with you? I share it with you just to give you a sense of what really goes on in these medical malpractice cases here in New York. You know, I recognize and I understand you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.